We're on.
All right, well, welcome everybody. We have lost a few people, and I know it's a legal topic, so it's very scary always. I'm a lawyer by background, but I'm very much deeply involved in business issues as well, so I like to speak about law in an understandable way. So please raise your hands. I don't know how many lawyers we have here, or is it more on the technical side? Okay, one lawyer, okay. Oh, more lawyers, okay, good. So don't be scared of a legal topic. I was trying to highlight 3 specific topics, but really happy to take questions on anything else about GDPR and how this applies in practice and what are really the top concerns of customers. So, with this one, what have I done?
I think you've done backwards.
Okay. All right. Well, stating the obvious, I mean, today is the day. I mean, I was watching the TV in the morning, and on BBC, GDPR was among the top headlines among North Korea summit cancelled. So this is, gaining so much attention. You're shaking your head, you disagree, it shouldn't be there, but it was there. And it's interesting what the read of the reporter was. So they were basically discussing, as we experience this all as private persons, that, okay, will I stop receiving all those emails and direct marketing emails? And I'm sure that we have all experienced the same thing in the past days, that you receive so many reminders that I have data about you and click through if you want to stay in touch. So this is becoming very real today. Now, okay, I need to figure the right direction here. So what's the impact on the business and why is this important? And I mean, I'm sure that you have all heard about the fines which are attached to the enforcement of this new regulation, and the number is really mind-blowing there. So 20 million euros, or up to companies' 4% of annual worldwide turnover. So this is now really a boardroom level issue. I think that's fair to state. Even those who were just, shaking their heads earlier and nodding like, yeah, privacy or protection, we all have to deal with this. This has become a really, really significant issue. And then really the impact is far beyond Europe. I mean, I think that's also important to note that, okay, I'm getting the wrong direction on this one. Yeah. So if I'm asked about the scope, obviously companies would want to know, like, does this really apply to me? I don't think it does. I'm not that European, actually. I think the bad news is that it would even apply to Santa Claus, and not because only he's a Finnish resident and his main establishment in Lapland, but because his business is really targeting the European Union. So it's all about European citizens. And these days of the 4th Industrial Revolution, again, stating the obvious, I mean, every company is a data company, no matter whether you're in public sector or whether you're a startup, you're a financial institution or an NGO, you do process personal data. So if the text of the General Data Protection Regulation has been published 2 years ago. The regulators are saying, well, organizations had 2 years to prepare. So in the past 2 years, I think what sort of showed or described the temperature really well was something like this, like, get ready. I mean, are you preparing? What are the steps? Companies are offering various pillars how you can get prepared. Well, I think in the past months, but weeks definitely, it really changed to this one. This I received from a customer, one of my favorite ones. Like, really the anxiety level is now very, very high. And everybody's asking, like, okay, so are you ready? Who is ready? Who feels comfortable to state today, on the day of the enforcement, that we are ready? So, as I said, today is the day. So what will happen tomorrow? Are the regulators really ready? I mean, if you look around Europe, I saw a recent statistic that actually out of the 28 member states, most of them have not adopted implementation laws. And you could say as a lawyer, well, it's a regulation, so you don't necessarily need an implementation law to put this in place. However, in practice, this means in a number of countries that the Data Protection Authority, which has been operating there for decades, is not directly empowered by the local government to investigate these issues. So I think it's fair to state that this is really a journey for everyone. And there will be so many learning curves, and there are no black and white answers. Now, really about the requirements, I mean, and I don't want to get into the legal details. I mean, you can look at it from this end to the other. complex and really lengthy legal requirements, very, very strict. It's all about protecting the privacy rights of individuals. And I'll talk a little bit about the specific data subject rights, which I hear from customers oftentimes that this is of high interest. And then another area, which I will not get into, but we can also discuss in the Q&A session, is breach reporting, which was making headlines. And obviously, these days, I mean, with all the security challenges everybody's facing, this is so important. And there's a 72-hour breach notification requirement for data controllers to their authorities, which is kicking off basically today. And then I have already mentioned the sanctions. I think it's important also that, I mean, if you talk to your own company, your boardroom, it's not only about the fines. It's really about the reputation as well of the company. I mean, if you think about Cambridge Analytica or other recent examples, I mean, that can really kill a company if they don't handle something in the right way. So what do you need to do and what can you do? I mean, high level, obviously, we all know that there need to be tighter controls, better data governance tools, and then improved policies and processes. Nobody will know a black and white answer, to be honest, for all the questions you have. What you can do is have all your stakeholders and have an open discussion on how you can actually mitigate certain risks. And this is all about, I mean, the basic principle of accountability. And this is what the GDPR drills down to. I mean, it's specifically, these are the principles the GDPR specifically highlights. Some of them were existing principles, like data minimization, don't collect more data than you actually need. I think part of that in the previous presentation was about dark data, which they don't even know exists, and the rest which you don't need. So that we really adopt something and processes where we are more principled in that. I mean, purpose limitation is really don't use data for other purposes than you have collected them for. And there are, I think, various examples in all our practices how that is happening. Feel free to move my bag. That's mine, and you can put it down. I'm not going to sit down while I speak, so no, put it over. And so basically, and don't want to spend time explaining all the principles, but I think it's really the underlying intention of the regulators was to adopt a framework when privacy is not a tick box exercise. When you have to really thoughtfully think through your own systems and what you have to improve there. And they will also, in Microsoft, we have teams of commercial lawyers, we have teams of policy specialists who talk to people in Brussels and the regulators. And the regulators are also very clear that they don't have all the answers in advance. What they will be looking for is really accountability, that your organizations are taking the right measures to the direction of being accountable and doing whatever you think is necessary. So I think that really takes to the notion of shared responsibility. I mean, we hear this from customers so often that they hope for an easy solution. We would all love an easy solution, a green button, something to press, how much it costs, and then do we implement it or not. But that doesn't exist. And anybody who is claiming the contrary, I'm not sure that person is so credible. It's really about the shared responsibility. Who needs to do what? And that means a shared responsibility between you, who own the data as companies, and then whoever you use as vendors and how many of them. So you have to be obviously very careful about allocating that data, choosing the right vendors, holding them accountable for their responsibilities. But at the same time, you can't outsource your own responsibility. And that means also that within the company, there are so many stakeholders of this. I mean, we as lawyers, I think, know that, data protection traditionally used to be like a legal topic. So someone had a question about data protection, they went to the lawyer and asked the lawyer. Now, there are so many questions interlinked with security. Then I'm getting these questions all the time from IT security experts, like, okay, whose job is this? Is this my job or is this legal's job? And where do we draw the line? And I think it's pretty clear that there's no line. I mean, that's really what it's all about, that people have to break down the silos within their own organizations and start to talk to each other. And if it's HR data, you probably have to loop in HR, how you deal, for example, with candidates. If it's about finance, you will have to talk to those people. If it's about developers and how you develop software, you need to loop them in. And most importantly, I would highlight, this is a boardroom level issue. So you have to have the support and buy-in from your own executives. And that will be something you will have to demonstrate in case of any supervisory inspection or any questions, because if this was not taken seriously enough within the organization, that will not be a factor in your favor. Now, these are some quotes from a webinar we had a couple of months ago, and I just wanted to highlight two words there basically. I don't know whether this pointer, oh, it worked, it doesn't work, on sustainability and automation. So I think that's also important, that this is not a one-off exercise. You can buy the most fancy product, which will do this and that for you, categorize the data for once, but then you have to implement it. You will have to use it. You will have to think about something which is sustainable. And obviously, automation can help a ton. So moving on to one of the areas which seems to be a core concern for everybody, is the so-called topic of data subject rights. So as I started to kick off in the beginning, it's all about protecting natural persons' data, the data subject data. So those can be your employees or your customers if you're in consumer business. So what can they come and ask for basically from today? Well, they can ask for these things. They can ask for transparency, basically understanding what data you hold about them, and they can actually file specific requests that they want to know what exact data you have of them. And the challenge there is that this needs to be provided in a form which is easily intelligible. So if you think about a more complicated service, that can be terabytes of data. So I think in practice, implementing this in a way that you produce it in an intelligible format is going to be challenging. Then obviously they can ask that, for the correction of that data, and they can ask for the deletion of that data. That's also a notion which is referred to the right to be forgotten. What does that mean? And we already had the question, I think, in a previous session about backups. Erasure is erasure. So it means that it needs to go away from backups, but also think about this, that this is not a universal right. You may have exceptions which are applicable. You may have legal claims or legal holds for which reasons we cannot ask for or the data subject cannot ask for the deletion of the data. So if you think about investigating a fraud, then the suspect can come with a data subject request and say, oh, please delete my data. I don't want you to hold it any longer. Well, that's obviously an exception. So this is something for which you have to establish policies where you clearly spell out, like, what are the exceptions. There are statutory exceptions as well for public sector entities. There are some data I can't ask any public sector entity, for example, to delete my IDs, my social security number, because they have a statutory right and obligation to maintain those databases. So think about these as not universal rights. And one very practical consideration I would offer is that the deadline to basically comply with those requests is 30 days. So I get often this question from customers like, okay, how long do we have to keep all the data, and how do we establish all the systems that we can provide, all this information? And basically it all starts with a good data retention policy. Because if you're principled enough and decide, what is the data you don't need more than 30 days for those systems, you don't need to build the data subject request capabilities. And the last one is automated decision making. A very complicated issue itself. It's a term introduced by the Gdpr where basically it says that we all as data subjects have the right to say that, well, we want human intervention. We don't want to be subject to an automated decision making in certain areas, which is basically affecting our legal rights. I mean, nobody really knows how that will be interpreted in practice by the various regulators. So how do we as Microsoft support data subject requests? And I just wanted to show you practical examples and what you can request from your vendors or what you can think about. So we as Microsoft providing cloud services are data processors. Our obligation for our customers is to support and assist with data subject requests. So what does that mean? We have on our Trust Center a description of the split of responsibilities. This is obviously reflected in our agreements as well, but now I really want to show you the depth, like what is there. So this is split up on the on the Trust Center itself to the responsibilities. Here is the example we're trying to use as clear language, not really some legal, very hard to read long terms, but for example, what does the GDPR require? And we are Microsoft's responsibilities as a processor. And it says in one clear sentence, we must implement the appropriate technical and organizational measures to assist you in responding to requests for data subjects exercising their rights. I mean, this is the easiest we can get to. It's not going to get less complicated than this because we still need to, transmit that information. And then what exactly is there in terms of the documentation? Because in practice, if you look at processor obligations like a cloud provider, we need to provide you a lot of information, but in a form which is ready to use, basically. So what we have put together are basically documentations per our service. We have a description, for example, for our Azure services. How do we support data subject requests there? And these are detailed guides, some of them over 50 pages, but this is something which you can take, print, copy, paste to your own data protection impact assessment, for example, if you use a new technology. Now, what else is there? There are tools, and I think that's even more important for the sustainability part, because we put you in control of doing those things. We will not be able to do these things for you in a sense that we can't evaluate whether you have, for example, exceptions or grounds you want to enforce, whether there is a legal hold, whether your, for example, employee or customer is coming to you and asking you, please delete my data, but you don't want to delete that. You don't want to allow that for someone else to delete it. So here are basically the tools and the admin controls which are putting you in the position to be able to comply with those. And these are very much attached to various services, and those are, as well described in the GDPR documentation I have shown. And then my last topic, which seems to be also such a hot topic, although this has been on under the previous data protection regime, is really international data transfers. As you may know, basically the GDPR takes a very principled approach and says that, well, within the European Union, actually the European Economic Area, the flow of data is free. But outside of the EU, you need to have specific guarantees, measures, which is called adequate level of protection or adequate safeguards for the protection of that data. This effectively means that the EU is extending the applicability of the GDPR beyond Europe, not only in the sense that, with everyone who is targeting their business to the European market. It's also in this sense that with international data transfers, they must meet these standards. Now, there are various ways to comply with that, and one of them is basically the decision of the Commission, where they basically choose specific states and say that under the very complicated criteria, they have determined that that state, for example, Canada, provides adequate level of protection from a privacy perspective because they have the right laws in place, they have the right enforcement structures in place, they have the right controls in place. and they're looking at tons of things. So in the easier sense, you have that list of countries, which is not particularly long, though. Then you have the Privacy Shield. I mean, you may remember the predecessor of the Privacy Shield, which was Safe Harbor, which has been invalidated upon the basically initiated lawsuit by Max Schrems based on various concerns. Now, the Privacy Shield is a new mechanism which has been agreed between the EU and the United States and determines principles to which companies have to agree to adhere to. It's a self-attestation system, so for that reason, it's still sort of questioned a number of times, and there is ongoing review of the Privacy Shield by the Commission. It actually passed the first review last fall, and it will continue to be basically reviewed. One of probably the most concrete or most strong protections for international data transfers is the so-called standard contracture clauses. You may hear reference to them as the EU model clauses. That's basically a contract, and that's what I'm saying. It's one of the most concrete things because it's a contract between you and us or you as any other processor, and you can see the contractual terms which you are provided by. And those terms, as I said, are predetermined by the Commission, so they cannot be changed. If you deviate from them, they become sort of ad hoc clauses. And then there are other mechanisms. I don't want to spend the entire time on that. Basically, two new things on binding contractual clauses. I just want to mention that they're slightly different in the sense that they are for intracompany relations. So, for example, if you have a company group and you have subsidiaries in various locations, you want to make sure that the data which is transferred between those subsidiaries is properly protected. You can think about adopting binding corporate rules. It's not a cheap procedure, pretty difficult to go through, but many advisors are able to help you with that. And then two new mechanisms, the code of conduct and the certification, which the GDPR mentions. Now, on those ones, I want to highlight that they need to be approved by some supervisory authority. It's either the newly established European Data Protection Board, which is consisting of the European regulators, or some local regulator. So as long as it's not approved, and the same goes with certifications, I mean, those don't make a difference. There are numerous certifications in place and numerous standards which you can implement and which you can use to demonstrate all the principles you have applied and you're requesting from your vendors. For example, ISO 27018 is a cloud computing standard, and there are loads of sector-specific standards from PCI DSS for financial payment, and so on and so forth. So those will continue to be important. There is no one GDPR standard yet. And we also have a standards team who work very closely with ISO, and my understanding is that it's unlikely that there will be one GDPR standard in the very, very near future. There are standards being adopted, like, for example, on data portability, ISO 19941, which is laying the ground for the groundwork on data portability and categorization, but it's still not all the details. So there is more work to come there. So what I wanted to also caution that we're talking about privacy all the time, but this is reality. I mean, we're talking about security
5 minutes. Go.
As important as privacy, and they really go hand in hand. So you have to take a holistic approach, I mean, and be very, very pragmatic on what you implement, because privacy cannot be implemented in a way that's basically undercutting security. And here are some data from recent Verizon data breach investigation report. Apparently attacks in organizations, 75% of them are instigated from the outside, but that means that 25% of them are inside. So what can you do? I mean, actually, we think that GDPR is a great opportunity to have a more holistic discussion about security and privacy, and have a more holistic approach and not just single solutions. And I'll probably won't have time to walk you through in details on this one, which is basically showing how you can protect information as it travels. So if you, and me as a lawyer can understand this even to sort of depth, that once you create a document, you put the right boundaries around the document, then it will carry it on and it will help you to enforce all the security and privacy measures which you will need to be able to deliver. So I would really close off by saying that look for companies who have the right bandwidth, who have the right overview. I mean, I can give you us, obviously, as an example, that we have really a unique position with our email systems, with 10 billion of authentications per day, with search engines, and with a cybersecurity center where we're working with law enforcement agencies for botnet takedowns. So choose your vendors very carefully, look at their capabilities, look at what they have. The cloud has the benefit that it's always current. It's always up to date. It is any cyber threats we are aware of and we learn, for example, in the botnet takedowns or in the work of our cybersecurity center, are built back into our products. So I think that is a unique offering, and you have to use highest care when you're choosing your own vendors. So a quick summary to wrap up on what you can do and what you have probably already done. But I mean, obviously, key steps. You can think about simplifying your privacy journey. I mean, it's hard to do all alone, and obviously it's also an allocation of responsibilities if you're using solutions and basically experts who come along the way. And then obviously, I mean, there are more and more detailed steps, and I'm sort of mindful of that I'm out of time. How you do that? I heard the previous presentation. Sometimes some companies have 4 pillars, others have 5, 3 steps. Quite similar, and there is a logic in this. What we have done at Microsoft is basically all our services are mapped against these. What are the solutions we can offer you, for example, for this requirement, management, data tagging, and so on and so forth. So I would really close off by saying, and this is just a quick overview of like what exists across the board and across the services and what functionalities can you benefit from. So to close up with, I would say here are some materials which are available for follow-up. Happy to answer any questions. And maybe it's pretty odd, but I think Happy Birthday Gdpr is a valid close. And I ask you, like, do you all feel ready? Thank you for your attention.
We've got a couple of minutes. Do we have any questions? Can I ask one before you leap away? You have one. You got one, I've got one. Wait, don't ask. My first one is, how many people in here are in companies that are below the threshold of 250? 250 people. Because there is a threshold. So you're all in companies with more than 250 people? No. Below. Well, I'm one. So you can, my question is, what's the difference?
Okay, I have.
From what sense? I mean, shall I take this one first? Or yeah.
I can ask a question, yeah? No.
Sure, go ahead.
Okay, we spoke about these binding corporative rules, and there was an issue then in United States. No, then in the United Kingdom. This process will take 2 or 3 years. Can you recommend other countries and how fast these binding corporative rules are done there? Thank you.
So you mean what exactly takes 2 years? The preparation, the approval? Right. Well, look, I mean, I don't think there is I'd love to say that, oh, pick this country and it's only 6 months there. Binding corporate rules requires, and that's why I said, it requires a significant investment. It's a long, long journey. So I would say that for the interim, you may want to consider alternative ways of protecting international data transfers. And especially also with the UK, I mean, with Brexit, I mean, they are having now so many issues, and their regulator, the ICO, is really pragmatic, but yet they will have additional issues as opposed to if you look at just an EU country out of the 27. And can you explain what exactly do you mean by what 250? Like, what's the
oh,
difference?
in the actual rule, there's a threshold that it doesn't. All the things will not affect companies that are smaller than 250.
That was only in the draft, so it does. I mean,
Does
really
it still in? So
yeah,
it's in for me.
So it
So
means
you want me to
so
follow all this nonsense?
So it means there are
There's
exceptions.
one person?
There are exceptions.
Who is
obviously.
the exception?
It's a long list of exceptions. Happy to take that offline.
I know the exceptions like police and things like that.
But for
what about
household data processing type of things, so what an average person would just do for his or her own purposes. But I think it all depends on what data you process. If you process just one person, sensitive medical data records, it doesn't mean that you're under 250 threshold. Okay? Didn't make you
One
happy
more.
with the answer.
No, you don't.
I have a comment and I can respond to your answer. The extension only, not extension, but exception only applies to data processing register. It's only one piece of Excel document you, as a small company, you don't have to make. So the rest is, you have to do it.
Exactly, and I think that the registration obligation has gone away in many countries anyway, so that's becoming less and less relevant. Yeah.
So if one part of a law is not relevant, all law is not relevant for that law. You know this, you're a lawyer. Am I right?
No, you're
I am.
not,
If one part of a law
unfortunately.
is irrelevant, the rest of the law is
But
irrelevant.
don't blame me for the GDPR. I mean, I
No.
haven't drafted the text. Thank you for your attention.
No, thank you
Yeah.
very much.